Pete, you'll be happy I'm starting off with my red button, so it's good. Going to be a sign of the day. Good afternoon, Senator Pearl. What's that? Senate Judiciary is now in session. The Honorable Senator Pearl is going to introduce SB 58. Welcome, Senator.
Well, thank you. Well, good to be here in front of Judiciary. It's not a committee I get to come to very often. For the record, my name is Senator Howard Pearl. I reside in the town of Loudon and represent District 17. I'm here today to introduce Senate Bill 58. This is a bill that broadens the criminal venue for prosecution in the county or judicial district where an element of the offense occurred in situations where all of the elements of the offense do not occur in one county or judicial district. So this bill establishes a court's venue, where a criminal case may be heard, to either the jurisdiction where the death took place or the jurisdiction where the manufacturing, selling, or dispensing of the deadly drug took place. This bill addresses the venue limitations outlined in a case recently decided by the New Hampshire Supreme Court. The direct impact of the Fortune decision is that individuals who provide deadly drugs outside the boundaries of New Hampshire cannot be held to account for deaths that occur within New Hampshire. So we had a little issue in the drafting of this bill originally. The original Senate Bill 58 was drafted incorrectly into the wrong chapter of law. We caught it, and I've provided an amendment for you that correctly reflects what we originally intended to put in, which is Amendment 0218S. And we have tailored the language just a little because of the passage of Senate Bill 15 last week created a little bit of a contradiction with my language that I was originally going to put in. So I believe this language that we're presenting to you today will not run any conflict with the bill that we just passed last week on the floor. And Paul Halverson, the county attorney from Merrimack County, is here, and he's the one that requested the bill for me to put it in. So I will hopefully get you to ask any of the technical questions of him more than me. So thank you.
Thank you, Senator. Sounds like a plan, unless someone has something. Thank you.
All right. Have a great rest of your day.
Thank you. You too. Attorney Halverson and Attorney Endres. Do you both have this amendment? Yeah. Okay. Awesome.
Drafted this letter with a language slightly different, but the intent remains the same. I'm Paul Halverson, Merrimack County Attorney. To my left is Steve Endres. He's one of the assistant county attorneys and our county solicitor. Last year, the Supreme Court came out with a case, State versus Fortune. And in that case, they basically addressed the issue of venue in criminal charges that addressed death resulting from drug overdoses. The impact of that was that out-of-state individuals, such as drug dealers in Massachusetts, who had sold to somebody who returned to New Hampshire and died from a drug overdose, could no longer be prosecuted. Immediately after this Fortune case came out, there were at least 4 cases that were pending that I know had to be dropped by the state. In my letter, I summarized those cases on page 2. They are redacted for names, locations, for obvious reasons, privacy reasons, case reasons. But they were passed to me by various county attorneys in the state. And it's that issue that this helps clear up. One thing to note is that the issue of venue does not create a new crime. It only allows a crime to be prosecuted in an individual court, in this case where that person dies. I'll defer to Attorney Endres to give a more complete explanation of the venue issue and some other issues.
Thank you. I always tend to try and start at the beginning so that we're all on the same page. So in New Hampshire, RSA 318B26 subsection 9 makes it a crime to manufacture or sell certain controlled drugs and makes the actor liable if there's a death resulting from the sale of those controlled drugs. The way these cases tend to come about is essentially the police find a dead body or are called to the scene of a dead body and find that it's drug overdose, and then sort of do an investigation and work backward to see where this person obtained the drugs from. So you have the department where the body is, tends to be the department who's done the investigation, who's invested in the investigation. If there's search warrants related to that investigation, for example, we may issue search warrants for a person's phone or social media. Those are generally issued through the local county attorney's office. If, for example, we find out in Merrimack County that a sale had occurred in Hillsborough, we now have the situation where we would have to bring those charges in Hillsborough, bring in the Manchester Police, the Hillsborough County Attorney's Office. As Attorney Halverson said, the New Hampshire Supreme Court came out with State versus Fortune in 2024, and the Fortune case essentially says that this crime has three elements. The first element is that a sale or manufacturing of a controlled drug occurred. The second element is that the victim took the drug, and the third element is that the victim passed away. The Supreme Court says only one of those elements is really an action on the part of the defendant, which is the sale. So the case has to be brought where the sale occurred. Unfortunately, as I said, that presents a problem for the prosecution, not just because the invested department tends to be the one where the death occurred, but we're finding more and more that drugs sales are happening outside of New Hampshire. For example, a lot of these sales occur in Massachusetts. So what this bill does is it seeks to remedy that by allowing the prosecution to occur where either the death occurs or where the sale occurs. There's similar statutes throughout the New Hampshire Criminal Code that establish venue. For example, there's an insurance fraud venue statute, an identity theft venue statute, and a computer crime venue statute, which all allow venue to be brought where the victim lives, where the loss occurs, not necessarily where I refer to it as sort of the action element where the sale would occur. So I think that this changes the purely statutory case of State versus Fortune to allow us to bring it where the death occurred. Attorney Halverson and I did reach out to the other county attorneys. We spoke with Keith Blair from the Carroll County Attorney's Office, who's in favor of this bill. Marsha Hornick from the Grafton County Attorney's Office is in favor of the bill. Pat Conway from the Rockingham County Attorney's Office is in favor of the bill. Chris McLaughlin from Cheshire County is in favor of the bill. Christine Hilliard from Sullivan County is in favor of the bill. Keith Cormier from Belknap County is in favor of the bill. And Emily Garrod from Stratford County Attorney's Office is also in favor of this bill. And we're happy to answer questions.
I just got an easy one. So I buy the product in Methuen. I use the product in Methuen. I die in Salem. You can get me then.
Yes.
You're being real clear. Okay. Go ahead, Senator.
Thank you, Mr. Chairman, and thank you for taking my question. So if someone were to buy drugs in Massachusetts, they bring it into New Hampshire, and they die of an overdose, wouldn't the person, though, that you're prosecuting in New Hampshire be charged with the Massachusetts law? I guess my question is, like, what laws don't apply for the distribution part? Because their distribution part occurred out of state.
I think I can answer that one. One of the police department's detectives in an email to me, again, I won't mention who or where because it's an active case still, indicated to me that Massachusetts does not have a similar law to our death resulting. He indicated in an email to me that Massachusetts may be considering one this year, but here we are. That doesn't solve the issue of venue in New Hampshire.
Oh,
And I don't have my entire RSA book with me here, but so it talks about I'm referring to the amendment that Senator Pearl provided. It says it's adding a new section under RSA 318-B:26. So I guess my concern is if the sale is in, I support the concept what you're trying to do, but I guess I want to make sure this works. If the sale occurred in Methuen, are they violating that law, the New Hampshire law? Because they're not in New Hampshire when the dispensing occurs. I know the death occurs in New Hampshire, but I guess, are we going to have jurisdiction over that person who there's no evidence that they came into the state?
So the current statute reads, any person who manufactures, sells, or dispenses methamphetamine, lysergic acid, PCP or any other controlled drug classified in Schedule 1 or 2 or any other controlled drug analog thereof in violation of RSA 318B21 or 1A is strictly liable for the death which results from the injection, inhalation, or ingestion of that substance and may be sentenced to imprisonment for life. I think when you look at the territorial jurisdiction statute in New Hampshire, which is I think 625(9), it indicates if any element or the result of any element occurs within the state of New Hampshire, that the state of New Hampshire would have jurisdiction. So I think to answer your question, if New Hampshire would have territorial jurisdiction under 625(9), the question becomes one of venue, where do you charge it? And we're hoping to remedy the venue question with this amendment.
Thank you.
Go ahead, Cinder.
Thank you and welcome. So to follow up on Senator Abbas's question, you may be, if the roles were reversed between Massachusetts and New Hampshire law with a death resulting statute, then it limits. You can only charge what in fact is a New Hampshire law, a violation of a New Hampshire law. So you're not going to go after the manufacturer of drugs or anything like that. Your case is going to be about death resulting if in fact everything else happened in Methuen.
Correct. We wouldn't necessarily be enforcing drug sale charges in Methuen unless there was a death resulting in New Hampshire.
And may I follow up? And then in fact in New Hampshire, your charge would be the death resulting charge.
Correct.
And Massachusetts can do anything else it wants.
Yes.
Okay, thank you.
If I could ask Attorney Andrews a quick question. We're not sure if the amendment, would be better within 318B26 within the, if you go to your statute, within paragraph Roman 9 IX, directly within that paragraph under a new paragraph, parenthetical, small c parenthetical, rather than adding it after 9-A. It's a technical issue. I think both of us think it would be better to have it under Roman numeral number 9, new paragraph, parenthetical c parenthetical. And beyond that, I don't think we have anything else.
Thank you.
Thank you.
Seeing no one, hearing is concluded.
Okay, thank you. Thank you, Mr. Chairman, members of the committee. For the record, I'm Senator Long, representing District 20, which consists of half the city of Manchester. Senate Bill 48 is a recommendation from the 2024 Committee to Study Restoration of Competency from House Bill 1020 of 2024. Currently, New Hampshire lacks in any formal restoration process that provides treatment for individuals who are found not competent to stand trial. Mental health courts are not an option because these individuals are deemed not competent and therefore not capable of consenting. Senate Bill 48 attempts to remove low-level misdemeanors as ineligible for restoration, also giving parties the assurance that discretion should be used in assuring that the person is not dangerous to others. Finally, Senate Bill 48 assures that those suffering from mental health aren't languishing in jails and hospitals for minor crimes. And to be in more detail, I believe you'll have testimony from NHMA
Thank you, Senator.
detailing it more.
Any questions? Seeing none, thank you, Senator.
Thank you.
Oh, no. Yes, I'm sorry, hold on.
Thank you, Mr. Chair. I didn't move fast enough. Thank you, Senator Long. I'm looking at line 10. And so the court still has, how would the court exercise this discretion?
This would give them the discretion to dismiss the case as long as they didn't find any violence or danger to the public.
Okay.
Actually, that'd be a good question for NHMA.
So it would be, they're only able to exercise this discretion after a hearing?
Correct.
Okay. Okay.
Thank you, Senator.
With, oops, sorry.
Holly Stevens.
Chairman, members of the committee, my name is Holly Stevens. I'm the Director of Public Policy at NAMI New Hampshire, the National Alliance on Mental Illness. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide through support, education, and advocacy. And on behalf of NAMI New Hampshire, I'm here today to speak in favor of House Senate Bill 48. I just realized I have a typo in my I sent it by House Bill 48. NAMI New Hampshire did ask Senator Long if he would sponsor this legislation. And to just first answer your question, Senator Altschiller, about the discretion, yeah, it would be after a hearing because the process would be that the competency would be raised. And then once the person had an evaluation determined they were not competent, at that point, the court could use its discretion as to whether it wanted to dismiss the charges or not. And there's a reason for that. When we first brought this up, there was concern that somebody could repeat offend and end up in the justice system again. And if there was an automatic dismissal of all Class B misdemeanors without any discretion on the part of the court, then some folks felt that somebody would be able to offend multiple times and never have to actually see if they regain competency. So that is why there is a provision in the bill giving the court discretion to look at the victim, the defendant, and the public and make a determination as to whether those charges should be dismissed. So as you heard, New Hampshire currently lacks any formal restoration system. And as a result of that, New Hampshire has a significantly lower rate of restoration than other states in the country. Other states restore about 80 to 90% of folks that are found not competent to stand trial. And in 2014, New Hampshire restored 44%. So we're about half as much as what the rest of the country is at this point. And the people who are accused of lower level offenses often spend more time in jail or in a mental health institution than they would have if they were found guilty of the crime in the first place. Spending up to a year in jail simply waiting to be restored without any services being provided in jail. And we did just recently hear from a mom of somebody who was released from Valley Street Jail after a year of waiting there pre-trial because they were found not competent to stand trial. They were released from jail with 3 days worth of medication and never did anything while they were in jail to help them get restored. As you heard last year, the legislature passed House Bill 1020, that established the Committee to Study Competency Restoration. They met several times throughout the fall and took testimony from a broad array of stakeholders. One of the recommendations, as you heard, was that offenses at the level of violation and low-level misdemeanors may be deemed ineligible for restoration. And they also did recommend that the court could have this discretion because of the concerns that were raised to the committee. As evidenced by the numbers of individuals ordered for competency evaluations, the need for these evaluations has increased substantially over the last 5 years, with some state jurisdictions reporting 70 to 100% increases. Accordingly, New Hampshire experienced a 75% increase in the number of competency orders since 2015. In 2019, there was an average of 66 court orders for trial competency evaluations each month. With the increase in numbers of competency evaluations, our state has seen delays in defendants having timely evaluations. As other states have done, New Hampshire could help alleviate this backlog by dismissing certain misdemeanors and violation level offenses when a defendant is found not competent to stand trial. Although they would use the service for the initial evaluation, once the charges were dismissed, the defendant would no longer need to be reevaluated to determine if competency had been restored at the end of the restoration period, which is a year. This crucial policy carefully balances the freedoms of individuals presumed innocent until proven guilty and the safety of the public while addressing a lack of resources to carry out these evaluations. The bill allows the court to exercise its discretion, as you've heard several times, to dismiss cases that lack violence, threats of violence, while also specifically prohibiting the dismissal of cases relating to stalking, endangering the welfare of a child, harassment, or the violation of privacy. While these charges likely already would not qualify for dismissal because it's only Class B misdemeanors and many of those are Class A misdemeanors, the reason that NAMI New Hampshire felt it was important to put them in the statute was in case the law changes. We wanted to make sure that those specific crimes were always exempted from this, from being able to be dismissed. The bill further provides that in instances where charges are dismissed, that any party can raise the issue of the defendant's dangerousness. The goal of this legislation is not to undermine the judicial process or to decrease safety, but to ensure that individuals with mental illnesses are not languishing in jails or mental health institutions for minor crimes that they have yet to be found guilty of. And to better utilize state resources so that we can alleviate the backlog at the Office of Forensic Examiner. And so for those reasons, NAMI New Hampshire supports Senate Bill 48.
Thank you. Go ahead, Senator.
Thank you, Mr. Chair. Thank you for taking my question. I appreciate the bill and the explanation that you gave in a few minutes after a study committee worked for meeting after meeting to come to these conclusions. The question that I have that's in your testimony here that says offenses at the level of violation or low level Class B misdemeanor may be deemed ineligible for restoration. And my question is, does that mean those folks get no treatment at all, no follow-up?
At this point, it would mean that, and I say that because one of the other items that the committee looked at was court-ordered treatment, outpatient treatment, and they opted not to do that. We are working, there's a companion bill to this bill on the other side that would have forensic liaisons help facilitate at least that initial appointment as well as other treatment. Likely that person would only engage until the charges were dismissed, but we're in the beginning stages of trying to develop a competency restoration program in our state. And so the hope is that at some point, we'd be able to figure out a way to make these folks eligible for mental health court or that they might be ordered to some sort of treatment instead. But that was something that the committee did not want to do at this point.
Thank you.
Seeing no other questions, thank you for your testimony.
Thank you very much.
Stephen Andres.
Good afternoon. My name is Stephen Enders. Again, I'm an assistant county attorney at the Merrimack County Attorney's Office. I've been a prosecutor for over 20 years, and I spent 15, 16 years in the circuit courts. I do oppose this bill for a number of reasons. First of all, I don't know that I've ever seen a person charged with a standalone Class B misdemeanor or violation with competency raised. I've been told it happens. Again, throughout my career, I have never seen a person charged with just a B misdemeanor or violation have competency raised. I hear that this is going to affect people in jail, but you can't go to jail if you're charged with a Class B misdemeanor or a violation level offense. So this isn't going to impact incarceration in any way, shape, or form, because again, you cannot go to jail on a B misdemeanor or a violation. It's not going to impact people languishing in mental health institutions either, because we can't put a person at a mental health institution if they're charged with a Class B misdemeanor or a violation. The only way we'd be able to put a person in a mental health institution would be to go through the probate court process. I don't understand why we would change the restoration period from what it is now to something special for Class B misdemeanors or violations. As the woman from NAMI before me indicated, we don't actually have a formal restoration process in New Hampshire. We're lagging behind the rest of the country in people being restored to competency. And to me, that's the real problem. What this bill does, though, is it just gives up on B misdemeanors and violations. It accepts that we don't have a restoration process. It accepts that why even bother, because we don't have the process. But what I have difficulty with is when I think about violations and Class B misdemeanors, to me, violations, I think of the motor vehicle code. You have people speeding. You have people driving recklessly. When I think about a B misdemeanor, I think about driving while intoxicated. I have a hard time with the idea that you could take a person who's speeding or operating recklessly or driving while intoxicated, have them be found non-competent, and then simply dismiss the charges against them and walk away. There's got to be more that we do. I think that dismissing cases in order to shorten the OFE's backlog is short-sighted. And it concerns me that we see that as a solution. I could say a lot of things about the OFE's backlog, but one of the concerns I have is that the OFE is a contracted position within the state of New Hampshire to a private organization who's agreed to provide these evaluations and provide them within the statutory time frame. Another concern I have with this bill is that it dismisses charges with prejudice. I would note that under 135-17A, normally these charges, if you're found non-competent, your charges are dismissed without prejudice, meaning that if we feel that you've been restored to competency, we can refile those charges. I don't see why we would dismiss with prejudice in Class B misdemeanor or violation level offenses. And as usual, I'm happy to answer questions.
How are we doing? We're all set.
Thank you.
Thank you for your testimony. Is there anyone who didn't sign in who would wish to testify on SB 48? Seeing none, I think the hearing's adjourned.
Opening the hearing for Senate Bill 141. Prime sponsor, Senator Gannon.
Thank you, Senator.
Welcome to the committee.
Well, good to see you all. There you go. Somebody's listening. That's a good sign.
I hear
Oh.
there are people watching the live stream,
Okay.
so
That's good.
address the larger audience.
I'll be on my best behavior then. Okay, so this bill, I was asked to sponsor, and you'll probably think it's interesting because it's sort of more from a defense view, and I usually am on the other side, but I am also on the side of justice, just like any other lawyer in the room or anywhere, or hopefully everybody. So unfortunately, in New Hampshire, there's a 3-year time frame to petition. So if I was arrested and convicted, or let's see, I'm sorry. Well, it's in a criminal case, so doesn't have anything to do with civil cases, just we start there. So if I'm incarcerated or under terms, I'm out on some sentencing, that home release or something, but this is ongoing. So, but we find new evidence, and so should be ingrained in all of us. If we have an innocent person, we don't want them to serve any time in jail, more than they already have. And it's unfortunate if they did serve time they shouldn't have. So if they have newly discovered evidence, or if it's forensics, if it's a DNA thing that at the time of discovery, they've come further in the technology. And so in New Hampshire, we have this hard and fast rule. You have 3 years to introduce this. Unfortunately, if they came up with a better, more dispositive way of doing DNA, or there's some other new scientific discovery, or there's new evidence, we want these people to be let go if they're innocent. Right now, we have this hard 3-year fast rule. There are 6 states that have similar limits, hard, fast date. 44 other states do it a lot different than we do. So we would like to be able to consider new evidence, and we would like to extend this period. So we want to create an exemption to the 3-year time frame. It's not going to be a hard and fast thing that you're going to get a trial. It's going to go to the court and the judge that heard the trial, if they're still there, and that they're already going to know the evidence in the case. They'll know if it's new evidence or not. They will also, it'll be up to them to decide, does it go any further? So everybody in jail who says, oh, I have new evidence, not all going to go to trials. It's just going to be very few. So there'll be a side that's going to say, oh, we're going to get flooded and buried with cases. Not the case at all. There'll be few and far between. Only when you actually really have new scientific evidence, you have new evidence. Other than that, the judge will look at it. He'll probably kick most of the cases, but if you're one of those good cases, you do meet the grounds, and the judge believes you're entitled to further court remedies, then they could have a new trial or something. But you're not going to see hundreds of people running for new trials. This will be a very rare thing in New Hampshire. And that's about all I know on this subject matter. But there are people behind me who know much more.
Thank you. Who asked you to put it in?
The Innocence Project.
The Innocence Project, okay. So a question for you is.
Sure.
The assertion that this would not all of a sudden flood the courts with everybody's got a new twist on what the evidence was that helped convict them in the first place, right?
So you're not going to have a retrial of evidence that's already, it would be if there was a new piece of evidence there, or if there was new scientific data. Geez, the DNA, it's better and more accurate than it was 10 years ago, and it can prove I wasn't the person. So it's going to be rare and exceptional that this will be used. But if you or I were that person, it would be very important to us.
Sure. All right, thank you.
Thank you.
Okay. Next, we have Stephen Endors and Paul Halverson. Andres, sorry.
Good afternoon. For the record, my name is Stephen Enders. I'm an assistant county attorney in Merrimack County. With me is Paul Halverson, who is the Merrimack County attorney. Both of us have been prosecutors for over 20 years. We do oppose this bill, and it's it's hard because we don't oppose the concept, we oppose the language. This is very similar to Senate Bill 507 from last year. And last year we had met with the Innocence Project and the Attorney General's office and tried to work on that bill and work on the language, but we just sort of felt like we never got the language right. A couple of the concerns that we brought up last year regarding similar language is that this amends RSA 526. RSA 526 used to be New Hampshire RSA, or used to be under New Hampshire laws, Chapter 192. That law, especially this section, Section 4, has really been unchanged since the 1840s. In the 1840s, this Chapter 192, which turned into 526, only dealt with civil cases. And you can see some of the language within this statute still is fairly civil and antiquated in nature, in the sense that it talks about the rendition of the judgment complained of or the failure of the suit. I'll be honest, I'm not really sure what those words mean because I think they're mostly civil words that were used in the 1840s. I think if you were to go with this language, one thing that I would suggest is paragraph 1 says, a new trial shall not be granted unless the petition is filed within 3 years. I would suggest that you change that to say, a motion for a new trial shall be filed within 3 years. Just to try and make it clearer that all we're doing is changing the statute of limitations and nothing else. Again, I'm not sure this belongs in RSA 526. We talked last year about there's a post-conviction DNA testing statute in New Hampshire, which is 651D. And I'd like to see that either 651D expanded to include other forms of scientific evidence, not just post-conviction DNA testing, or have a new section of 651 brought in that deals with other types of scientific evidence or evidence which we would refer to as scientific evidence that now we have a new understanding of the strength of that evidence. I know that it's been referred to in a number of states as a junk science bill, that things that at one point we thought were really good science that we found out maybe aren't such great science, but were used to convict people. We certainly want to re-examine that, and I think there should be a method to do it. I just don't know that it belongs in 526. Attorney Alverson did reach out to the other counties. We spoke with Marsha Hornick from Grafton County, Patricia Conway from Rockingham County, Chris McLaughlin, the Cheshire County Attorney, Christine Hilliard, the Sullivan County Attorney, Keith Cormier, the Belknap County Attorney, Keith Blair, the Carroll County Attorney, and Emily Garrod, the Stratford County Attorney, and all of them felt similar to us in the sense that they oppose not necessarily the concept of the bill, but the language and putting it into RSA 526.
Paul Halverson, Merrimack County Attorney. I support what Attorney Indris said about all of us wanting justice for individuals that are charged with crimes. That's not the issue. A couple amplifying comments to what Attorney Indris mentioned. The wording in this concerns me in that it doesn't have an end point. When you look at the new paragraph 2, it talks about the petitioner seeks a new trial for something that resulted in a conviction of a or misdemeanor. And the petitioner is incarcerated or subject to collateral consequences. The collateral consequences may be long-term in nature that may go on decades because they may include voting issues, denying voting rights because of convictions of a felony in certain states. It may include firearms restrictions under federal law. It may include immigration issues under federal law. So there's really an unknown end point using the language that's in the proposed statute. In paragraph 2C, it talks about newly discovered evidence exists. My concern would be that's, again, a very overbroad statement. There doesn't appear to be a standard on how you evaluate that evidence. Is it credible evidence? Is it reasonable evidence? Is it accepted evidence? again, overbroad, and you couple that with the length of time, you basically have no end point to this. And I certainly agree with Attorney Anderson when he talks about the statute talking about DNA evidence. Last year, the conversation with the committee that we had was, when we were looking at this from the proposal from last year in 507, in Senate Bill 507, was a more robust analysis using the structure that was in place, that is in place regarding DNA testing. And I would note that Governor Sununu even commented about that in his veto letter of the original 507. The veto was obviously sustained on the backside. Again, he comments, and I'll paraphrase, he understands and agrees with the notion of not barring evidence of exoneration. But now I'll quote from his letter. The open-ended language of this bill could have the unintended consequence of encouraging baseless assertions, unnecessarily bogging down procedures. His language, not mine. That's the end of the quote. He goes on to comment by summary that the best method may be to look at a bill that's more comprehensive along the lines of 651D. And I can tell you that the county attorneys and every prosecutor I talk to agrees with that approach, to make it a very comprehensive approach to how this happens, rather than a broad brush approach that appears to be within the language here. And frankly, if Attorney Anderson and I were happy to work with the Innocence Project last year in trying to make this happen. We just couldn't get to that wording. And I wish that they had reached out to us prior to asking about this bill, because we certainly would have worked with them to try to work towards a more comprehensive bill as under 651. Thank you.
Thank you. Question for you. This is twice now that you have invoked the affirmation from other county attorneys that are supporting. Do you have a letter saying that they're signing on to your assertions here in this testimony, or is this just, casual conversations? It's a, that's a big deal to say
Yes.
that a county attorney has endorsed my point of view, but provide no letter to say, actually, they did.
And
So
it
I'm a little
may be more
uncomfortable.
appropriate for Attorney Halverson to answer that.
I can tell you this was a topic at various meetings with county attorneys over the last year and a half, since the 507 was up for a conversation last year. It was also a conversation in an email that my request to them was that, what's your position on this? Some of the email went back to both Attorney Anderson and myself. Some came only to me. That's why I'm answering this question. And every one of them agreed that, yes, this deserves a bigger look. And I'm confident in saying that nobody over the conversations I've had in the last year and a half is opposed to the concept, only the language.
So on that vein, last year, Senate Bill 507 passed.
It did.
In both bodies.
It did.
And the language is just a little bit different than what is being brought forward here today. Would you be amenable to an amendment that brings us back to that space that everybody was good with in the last session?
You mean returns it to the language of 507 from last year?
Mm-hmm.
I would not. And I refer back to, I don't have the date of my letter, but I had sent a letter to, I believe, one of the committees, it may have been this committee, that talks about my position about that. And I'll read you a small portion of it.
Please.
As you consider your options, I'd like to close with a cautionary statement. This section, RSA 526 of our statutes, has not been changed since 1842. Careful analysis and consideration should be exercised in deciding whether or not minor change in an antiquated statute untouched since 1842 is sufficient, or if a more comprehensive approach along the lines of that addressing DNA evidence, Chapter 651D, is warranted. I believe that a more in-depth analysis and comprehensive proposed legislation would yield better law. My paragraph goes on from there, but my position about that has not changed. I really think we can get to a better statute if we do it along the lines of the structure out of 651.
thank you for that clarification. So I'm going to go with what you just said to us, that in concept and the ideas around this are something that you both support.
Yes, certainly.
And so Senate Bill 507 was not the language that you wanted to get behind. It sounds like Senate Bill 141 is also a challenge. Would you provide language that you could get behind? So maybe we could have a discussion that would get everybody to good, because if we have not addressed this since 1842,
Right.
seems like we might be overdue. Maybe, yeah. Like, would you engage in that discussion to have, some sample language? I agree with you. Personally, I agree with you that I don't like the open-endedness of it myself. And so perhaps there are spaces in here where we can come to an agreement with advocates that would bring us a little bit further from the 1842 statute to a space where we can acknowledge that there are newly discovered evidence, in trials now, and that we have different ways of evaluating that evidence with forensic testing and so on. Is that something that you would be amenable to providing some language that you could get behind?
I'm not opposed to it.
Awesome.
I think that time is the big issue, and coordination is the big issue, because obviously we try to coordinate the language with various stakeholders, to include the Attorney General's office, the other county attorneys. And I don't know if you're talking about this legislative session or next legislative session. That's something I don't know if it's time crunched on the front side, but we gladly assist and try to get to language that's workable.
I look forward to seeing that work product. So, and understanding its work product, and so that we can engage in a productive move towards doing something that would allow for an opportunity for reevaluation of some of these.
On a little bit of background, we had actually asked the question a couple months ago to, I forget who we asked, if this was being brought forward again in this legislative session, because we hadn't seen anything that had been proposed, because we were hoping that we could weigh in and work towards the solution we had talked about last year. And we were told that the issue had not been brought forward. And so frankly, I was kind of surprised when this proposal became public, because the information we had from about 6 weeks ago, give or take a little bit, was that this issue was not going to be raised again for this year. And if it had, we would have certainly worked 2 months ago with the people that wanted this to work towards better language.
All right. Senator Gannon? Okay, great. Thank you very much.
Thank you.
We have Cynthia Musso. And Winnie, thank you. This is our last person.
I apologize.
Yes.
I'm recovering from a cold, so I'm
Thank you.
running a little congested. I'm Cynthia Musso. I am a staff attorney with the New England Innocence Project. For those not familiar with us, we work to prevent and correct wrongful convictions in the 6 New England states. Prior to joining NEAP, I was a public defender in New Hampshire. I was a staff attorney in the Manchester office, and I also clerked in the courts of the state when I graduated from UNH Law. I say all this to say that I am sort of in the unique position of understanding exactly how this statute of limitations is impacting wrongful convictions here in the state, and how the changes that we're requesting today are not only going to be able to free innocent people, would also be able to improve the criminal legal system as a whole. I think one of the things that I've heard today, and one of the things that's been repeated over and over, is a misconception about what we're trying to do. So I just want to be super clear that RSA 426 is 6 separate sections. And as we all know, those sections should be read in conjunction with each other and not to be inconsistent with each other. The standard for when a trial will be granted or not granted is in Section 1 of RSA 526. That states a new trial may be granted in any case when through accident, mistake, or misfortune, justice has not been done. We are not altering that section. That section has been here since the beginning and will continue to be the standard for granting a new trial going forward. The only thing we are trying to do is alter the time for when someone can apply for a new trial. Not whether it will be granted or not granted, only whether you can apply. The county attorney has spent a lot of time discussing the fact that we should put this into RSA 651 and that this is an old statute and it doesn't make sense to modify it this way. The practical reality is we're not trying to accomplish what RSA 651 is doing. This statute already exists. Under the terms of this statute, newly discovered evidence and scientific discoveries and new scientific understanding would still qualify as accident, mistake, or misfortune. That would still qualify. We are not changing that. That list of newly discovered evidence is a narrowing list, and I'm going to explain a little further. So the relationship between RSA 526.1 and 526.4 is only that 526.4 says you cannot file these petitions beyond 3 years following the conviction. That's a hard and fast stopping point. What we're trying to say is that we want to be able to file these petitions later. Not that they should be granted, not that a new trial should be granted just because there's new scientific evidence or just because there's new evidence. That's a separate question. The court will have to determine whether through accident, mistake, or misfortune, justice has not been done. It's not necessarily the case that just because there's new science, justice hasn't been done. A justice hasn't been done question is a question that takes into account the entire trial, the nature of the trial, as the county attorney pointed out, whether evidence is credible and reasonable. All of that is contemplated by 526.1. What we're trying to do in 526.4 is say, we just want to be able to ask the court in these narrow circumstances if we can ask for a new trial. That's it. I'm not trying to expand the number of new trials that would be granted. That would still fall under 526.1. I'm merely trying to expand the timing for when we can apply. So the issues that the county attorney is pointing out are really sort of irrelevant in that regard because we're not trying to change the standard. 651D does exist. And I just want to be super clear that in 651D, there is no time limit. And there is no time limit because DNA technology changes and science changes and new evidence becomes available as time moves on. And we don't limit that because there isn't a time limit on when science stops and technology stops developing or when our understanding about science is developing. We've learned this over time with a number of things and not just DNA. We have a case in Massachusetts where this man was accused and convicted of a horrendous murder based on bite mark evidence. His name is Gary Sifazari. The original expert that had testified in his trial, after learning more through over time, recanted his testimony and said, you know what? What I said at this time was that this was a human bite mark and that these bite marks were made by Gary. I can no longer say that anymore. Recanted his testimony. On the basis of that recantation, we were able to get DNA testing. And that client went 3. It took 35 years. It took 35 years. He wouldn't even have been able to get into court here. He wouldn't have had access because we didn't have the ability to ask for DNA without that piece. There's only been 3 exonerations in this state. That's completely inconsistent with the percentage of exonerations throughout the country. And I think one of the barriers to that is the statute. We're reducing the pathways that innocent people have to be able to get into court when we're saying you only have 3 years. I am litigating a case right now. It is a DNA case. It took the state 2 years to get me discovery. It took a year for the state forensic lab to test it. I haven't even been able to consider this statute because I'm still litigating under the DNA statute. I don't even have the ability to access the statute now without knowing what the DNA is going to be or not be, and that's a separate issue. but it's taken too long, 2 years just to get that. It, on average, takes 11 years for a case to, an exoneration to come to fruition. That's almost triple this timeline. This is just asking for us to be able to get into court. We were very clear, and we tried with this iteration of the bill to be very clear that this is not altering the statute. That's why we put Section 4 of the statute, the new bill, in, which specifically says we are not trying to alter the standard, because we've been trying to clear up this misconception that was made in the governor's veto that's been alluded to by the county attorneys over and over and over, that that is not what we are trying to do. This standard exists. Those things would fall within this standard now. We're just trying to expand the time in a very limited circumstances where we can apply for that. So it has been suggested to us that we could say the 3-year limitation could be abandoned for good cause shown. And we said that is too much. That would encourage a flood of litigation. So the reason we created the newly discovered evidence list was to limit the number of cases where you could even apply. I know from practice in courts, I know from practice as a public defender, that the most of the litigation that's done post-conviction, pro se, which folks without an attorney, is about legal issues. And that does not fall within this. You cannot apply for this on the basis of new legal issue. It has to be facts. It has to be new facts. The reason this new trial bill is particularly helpful is because this goes back to the court where they're from. So when you look at this and you say, is this newly discovered evidence? The judge has the ability to look at the file and go, you knew this at the time. This isn't new. You don't meet the statute of limitations. You kicked, dismissed, out of hand. No hearing, no lawyer, no nothing. This is a very small fix that could create a pathway for folks that are innocent, and that's why it's so important to us. I really have spent most of my time addressing some of the issues that I've heard today. The piece about the 1840, and I think in the civil issue, I don't exactly know the relevance of that, but what I will say is this is used in criminal court. I practiced, I know people that use it. This has been used. It's a regular means of getting back into court for very short-term fixes. We find stuff out after trial. Very quickly, we ask for a new trial. But it has to be very quickly. The direct appeal, which you are guaranteed by means of a jury trial, takes a year itself. It just wouldn't give us enough time. I want to just hit a couple other points that I made. I talked to you about Gary a little bit. And the 3 years and the 3 exonerations. So essentially what we're asking for is a very small fix to this time, this timing. It's interesting to me to come in today and hear that we didn't have this discussion, because we did sit down and discuss it. And I thought we were all on the same page, but apparently not. But the context of this statute makes it clear that we're not attempting to do what's being suggested that we're attempting to do. And this would make a huge difference for a lot of innocent folks sitting in prison. I'm happy to take questions.
Good afternoon, Senators. My name is Winnie Yee, and I'm a state policy advocate at the Innocence Project. We are a nonprofit organization that works across the country to exonerate the innocent and enact policies to prevent, reveal, and address wrongful convictions. Today, we are expressing support for Senate Bill 141, a bill that would improve the post-conviction mechanism in New Hampshire. And just to add on to what Cynthia said, I want to be clear that this has been a really thoughtful, intricate, intentional approach. When we approached this problem, we really tried to evaluate the best way to move forward. And we believe that this is not a broad brush at all, but it's an important fix that will have a huge difference and ensure that innocent people are no longer languishing in prison. As you noted, a version of this bill was first introduced and passed both chambers favorably last session, and we appreciated the opportunity to speak with various stakeholders about it, including some of the folks who are in this room. We would like to thank Senator Gannon for his leadership in sponsoring this bill, as well as the more than a dozen legislators who co-sponsored Senate Bill 141, including Senators Ennis, Pearl, Murphy, Waters, and Rosenwald. A wrongful conviction occurs when an innocent person is convicted of a crime they did not commit. It is a symptom of a broken criminal legal system that must be fixed. Since 1989, there have been 3,653 known exonerations. That's over 3,600 innocent men and women who have collectively lost more than 32,000 years of their life to a wrongful conviction. Over the years, the increasing availability of DNA testing, as well as advances in forensic science disciplines, have enabled the wrongfully convicted to prove their innocence. However, in New Hampshire, there are still barriers in the law that prevent innocent granite staters from being able to get back into court in the first place. Under current law, an individual must file a motion for a new trial within 3 years. This strict deadline fails to take into account the real-life process of revealing and correcting a wrongful conviction. In many cases, exonerees have had to wait years before new evidence was uncovered in their cases or new forensic testing was available. A 3-year deadline makes it nearly impossible for an innocent person to be able to get back into court to demonstrate their innocence. To address this, Senate Bill 141 would provide a narrow exception to the 3-year statute of limitations and would allow an innocent person to file a new trial if there is newly discovered evidence in their case. Under the bill, an innocent person would also be able to file a petition if their case involved discredited or new forensic evidence. Misapplied forensic science is the second leading cause of wrongful convictions. And as the research on scientific disciplines evolves, it's critical that an innocent person has an opportunity to petition for a new trial if the science used in their earlier conviction has been debunked. To be clear, the goal of Senate Bill 141 is to provide a much-needed pathway for granite staters to file a petition if there's new evidence of their innocence. No person will be released from prison the day this bill takes effect. It simply allows a wrongfully convicted person to access due process. Petitions will still have to be evaluated by courts and be reviewed. While some claim that Senate Bill 141 will lead to a floodgate of litigation or a significant impact on resources, the Innocence Project can attest that in the history of working on these reforms, that has never been the case. There are disincentives for guilty people to file claims because unfavorable results can negatively impact other appeals and their ability to be paroled. This bill is really about revealing wrongful convictions, one of the gravest mistakes our government can make, so we can begin to address them and make our criminal legal system more fair and accurate. So thank you for your consideration today. We encourage you to report it out favorably. Thank you.
Thank you. Any questions? All right, thank you. And that is the last person to speak. So we're going to close the hearing on Senate Bill 141. Is there anyone else here who wanted to speak? I don't think so. Okay.
No. We will now open the public hearing on Senate Bill 289 relative to the use and preservation of body-worn camera recordings in certain matters. Here to introduce the bill is Senator Gannon.
Thank you, Senator. I'll be very brief as there are more learned persons behind me on this subject matter. But basically what the bill does is deals with body-worn camera recordings. What happens when, copies are made and given to a prosecutor and defendant, and sort of a chain of when they can use it, when they can copy, and when it needs to be, these copies need to be destroyed at different points in the proceeding. That's about all I have on 289. Mr. Chairman.
Any questions from the committee? Seeing none, thank you, Senator, for your testimony.
Thank you.
This time the chair recognizes Roger Phillips. Is there a member from the parole board present?
Yes. I'm Roger Phillips. And then I could just wrap it up in an administrative point of view.
You would like that back cleanup? Understood. And I'm having trouble reading this, but Stephen, you got it. Your handwriting is as good as mine.
Good afternoon. For the record, my name is Stephen Endres. I'm an assistant county attorney in Merrimack County. With me is Paul Halverson, the Merrimack County attorney. We are both in support of Senate Bill 289. The language in this bill is similar to last year's Senate Bill 362, which was amended to refer the bill to the Law Enforcement Accreditation Commission over Police Standards and Training for their opinion. I know that the Law Enforcement Accreditation Commission met a number of times this summer and fall and did come up with some recommendations. I think within their recommendations and in general, there's a recognition of some of the shortcomings and ambiguities in RSA 105D2. RSA 105D2 is the state's comprehensive body-worn camera statute. Where I say that there's some shortcomings and ambiguities in it is that clearly within 105D2, it indicates that body-worn camera recordings are not to be copied, shared, altered in any way. The difficulty, of course, with that is we have to send it out as discovery in criminal cases, which certainly becomes difficult if we're not allowed to copy it. In addition to those prohibitions against copying, there are some clear privacy protections within 105D2. For example, access of the body-worn camera should be for law enforcement purposes only. There needs to be an audit of who accesses the body-worn camera. There's storage requirements that the body-worn camera has to be stored in compliance with the FBI's CGIS, their Criminal Justice Information Systems policy, and the body-worn camera can only be retained for certain periods of time. Of course, since there's nothing about discovery in the statute, what becomes difficult is that if a copy of the body-worn camera is made and provided to the county attorney's office and provided to defense counsel, none of those privacy protections that exist in 105D2 follow that copy. Once the copy is made, there's no longer a prohibition on copying the body-worn camera. Once a copy is made, there's no way to ensure that access of that copy is for law enforcement or official purposes only. There's no way to assure that it's securely stored, and there's no way to assure that it's not destroyed after a certain time frame. What this bill does is it makes it clear that body-worn cameras can in fact be copied for criminal and administrative hearings. I know that there was some discussion last year about civil hearings, and I know there's some people behind me that are interested in adding civil hearings into this bill. I certainly have no objection whatsoever to adding civil proceedings into the bill. I can honestly tell you the reason it's not there is because we're prosecutors, and I wasn't really thinking about civil when we wrote this language. But I certainly don't have any objection to adding civil litigation into the bill. But what this bill would do is make it clear that if body-worn cameras are copied for civil litigation, for criminal litigation, that those protections within 105D follow the body-worn camera recording, that it can't be further copied, it can't be distributed, and at the end of the litigation, the copies would have to be destroyed. If you have anything to add.
The only short comments I have to add is that this really winds up protecting the privacy of victims and witnesses, as well as the privacy of a defendant. It also protects the process rights of a defendant in a criminal case because it makes sure that body-worn camera video is available for any post-conviction litigation that's addressed within our document. In short, it balances all the protections that are needed throughout the spectrum of people who are encountered, who are involved in the criminal justice, and there is a civil process as it's going forward, and affords the privacy protections that 105D2 envisioned when 105D2 was originally implemented. Beyond that, I have nothing to add, and will certainly answer any questions you may have.
And just before we get to the question, the one thing I would add is that, as with the other bills, Attorney Halverson did email the other county attorneys to get their opinion, and we had heard back from County Attorney Patricia Conway in Rockingham County, Chris McLaughlin in Cheshire, Keith Cormier in Belknap, Keith Blair in Carroll, and Emerly Garrod in Stratford, who all indicated that they did in fact support this Senate bill.
Go ahead, Senator Evans.
Thank you, Mr. Chairman. And thank you for taking my question. I see, I understand that the existing law, you can't even make a copy of it for discovery, which is problematic. But I know you can't alter the photo, at least changing its contents in any way. But I've come across scenarios where, if you pause and you have a kind of a screenshot of it, but it's really dark, you can enhance the lighting yourself. And I always had the original, and then obviously the one that I added the light just for, to make full disclosure. But I guess in that case, I don't feel like I'm manipulating the content of the photo. It's really dark in the photo. Would that be appropriate maybe to add to this as well? If it is a dark photo or dark video, you can add, I mean, obviously you got to make that disclosure. You wouldn't be permitted to do that under any circumstance as this is written.
We did indicate within this that you could use the body worn camera video to create exhibits. Our thought was that you could cut it, you could paste it, you could freeze it, you could zoom in. Certainly, I think when you start changing lighting, and even when you start zooming in, I've recently learned, depending what program you're zooming in on, it automatically changes some of the pixels, which is actually an interesting, I think, new frontier we're on. But that's why I think that we wanted to keep the language broad, that you could use it to create exhibits. Certainly, I think if you're using it to create exhibits and changing the lighting, I don't know that that's necessarily prohibited by the statute, but I think you're going to have someone who can testify what they did to that body worn camera.
It's usually just me was changing the lighting. I always make the disclosure, but have the original. But I just didn't know if that would, it's up to the court if they want to accept,
And those were conversations that I had. I don't think Attorney Endress was in on all of my conversations, but that I had with other prosecutors. And if you look at the recommendations at lines 10, 11, and 12, it talks about subject to the relevant rules of evidence and rulings by the court. So that really puts into play motions in limine, motions to suppress. It accommodates those type of proceedings. It doesn't eliminate the requirement for authentication or items such as that in the normal process of the court. It doesn't make them instantly admissible in a court proceeding. The normal rules and process in court still apply.
Thank you.
Seeing no further questions, thank you both. Jessica King. Afternoon, Ms. King.
Good afternoon. Thank you for taking my testimony. Good afternoon, members of the committee. My name is Jessica King. I'm a senior assistant attorney general with the New Hampshire Department of Justice. I apologize, I could not find my name tag this morning, but I just want to apologize for that. I am here today at the direction of Attorney General Formella to testify on Senate Bill 289. I do think that this bill helps clarify the times that body-worn camera footage can be used in litigation. I do believe that body-worn camera footage may be currently used in litigation, but we always welcome clarification in the law. And so there has been some litigation over this aspect, especially in criminal cases. Body-worn camera footage has been provided over to defendants. However, again, we always welcome clarification in the law. In that vein, the use of body-worn camera footage in litigation does help further accountability in policing in this state. Furthers the goal of the LEAC Commission too. The department wants to offer that the bill should be amended to include civil litigation. At this point, it includes every other type of litigation except for civil litigation. Use of body-worn camera footage in civil litigation could be crucial. It can help hold law enforcement accountable when policing is violative of civil rights. And then it also can help in civil suits exonerate law enforcement officers when there has been no violation. So it really balances what is necessary in civil litigation, especially when enforcing litigants' civil rights. So the statute already calls for law enforcement to retain the footage for civil suits. This would just explicitly allow the use of that footage in civil suits. And so the AG's office would just ask that the addition of civil litigation be used or be added to this bill. And I'm happy to take any questions at this time.
Go ahead, Sandros.
Thank you, Mr. Chairman. And thank you for taking my question. I certainly appreciate this describes it when the footage, the body worn camera footage would be destroyed or disregarded. Is there any, I guess, I understand that it may seem obvious when a case is over to get rid of the camera, but is there ever any exception to that where they can have it preserved for whatever reason? If they feel like it's part of a larger investigation perhaps, or just wanted to come across that.
Yeah, so the body worn camera footage can be retained during the investigation if need be. If it's during a civil suit, I think I'd have to pull the statute up, but I believe the statute right now allows for retaining during that civil suit, not civil suit, is civil suits and administrative and criminal suits until the end of that criminal litigation. If a police department can have a policy, I believe from 30 days to 280 days, but don't quote me on those exact numbers, have a policy to destroy the footage within that time period. But if it's requested to be retained, the department is supposed to retain that footage during the pendency of those proceedings.
So just to follow up, in my private practice, this is more audio recording, but anyways, it was a much grander scheme, but two things off the side. They had a recorded, all the stuff. And then after those individuals pled guilty, so they completed their 3 or 6 months of probation and destroyed the audio recording. But then the bigger fish, which was someone I was working with, was charged with a conspiracy, and that was part of it. And as the defense attorney, raised this big sting about, well, you had this interview and you destroyed it. What happened? Now you're charging here, and we don't have that. And that had that been going on at the same time, it would have been a mandatory disclosure. But I'm not saying that the police department did anything wrong; they were following their policy. But as you say, I can exploit that if it's destroyed too early. So I just want to make sure we're not destroying the body worn camera too early. So do you feel that this time frame is sufficient? Should we make it a little longer, or is this good as? And I welcome the prosecutors to answer that as well.
Yeah, I think for what's proposed in this bill, it is sufficient because it's to the end of the case. It sounds like in the the fact that you presented there, it is maybe a issue of timing and notice of preservation of like, hey, this needs to be preserved for this other case that could be ongoing. But yeah, I couldn't answer to the mechanics of that.
And that hypothetical, just for, you had the state attorney general's office doing one thing and then local doing another, and I did think it was a miscommunication. The indictment on this didn't come down yet, so they wouldn't have known about it, and just the way the timing worked out of it. And I call that a loophole in my business, but at the same time, I don't want there to be loopholes. If we can stop that from happening, I think that's best policy. So
Yeah, and I think this does about as much as it can to address trying to close that miscommunication.
thank you.
Seeing no other questions? Thank you.
Thank you.
Marissa Chase, come on down. Good to see you as always, Marissa. How you doing?
You too, Senator. Mr. Chairman, how are you?
Doing well.
For the record, my name is Marissa Chase. I represent the Civil Plaintiffs Bar. It's great when I can say that I agree with all the prior testimony with the prosecutors and the Attorney General's office, and really respect and am grateful for their agreement that we should add in civil as well. So I have that precise language change, and I'm happy to email that to the committee as well. But it would be adding in civil in, trying to get, right here, I don't have the line numbers. Here I have the line numbers, so I'm trying to make it easy. 105D4, 1, after juvenile delinquency, comma, civil, comma, or administrative proceedings. So that would be line 8. And again in A, line 10, adding in civil as well, after delinquency, comma, civil or administrative. And then we would request adding in after F so after that concludes on line 27, G, the BWC body worn camera recordings requested for the purposes of investigation in a civil matter or for litigation in connection with the civil proceeding shall be released only after the criminal matter is concluded. We believe that one protects the, what do I want to say, sanctity of the criminal matter, and a civil case is always stronger if there is a concurring criminal matter once a criminal matter is resolved. And I want to agree with the previous speakers as well. This will not, evidence in a civil case, body-worn camera footage in a civil case is not just to prove that something was done. It can also be used to prove that something was not done. So we think that would be an important addition to this bill, and I will try to answer any questions you may have.
Questions? Nope. Thank you, Ms. Chase.
Thank you very much.
Last but not least, Roger Phillips. Batting cleanup
He's ready.
for the Red Sox.
Roger Phillips, and I'm chairman of the Adult Parole Board, and I'm addressing that third section after criminal and juvenile and also administrative purposes. Actually, within the last few months, we'd received requests for discovery in parole violation hearings and revocation hearings for body-worn camera evidence. And so that we had to look at what was being done from the criminal point of view with Superior Court orders that interpreted the statutes so that it could be used for law enforcement purposes, including criminal prosecutions. And with the advice of the AG's office, we also said that when that's requested in discovery and administrative proceedings, it could also be done, of course, in our hearings or provided in our hearings. Well, the difficulty, of course, is that we had to come up with a protective order in order to make certain that the statute would be complied with. And thanks to the generosity of the Merrimack County Attorney's Office, we were able to use what had already been successfully done in the criminal cases. So as far as I'm concerned, this statute would be most appreciative, and from an administrative point of view, at least to make certain that this evidence can be produced in discovery and offered into evidence in some cases. To date, no one has tried to introduce it, and the PPOs, the probation and parole officers, don't often use it. They just go with their usual testimony. But I just wanted to say, from an administrative law point of view, I support the bill.
Very good. Thank you. Do you have any questions? Seeing none, thank you for your testimony.
Thank you.
Does anyone else wish to testify on SB 289? If not, forever hold your peace. That ends that hearing. What? Sure, we didn't acknowledge my gavel there. I don't hear that.
Just reopen the hearing.
We'll reopen the hearing. Go ahead.
And just to clarify, my question is, I support as it's written. I'm just wondering if the retention period should perhaps be longer, if there's any benefit to that. Is it, obviously, I think you support the bill. So.
To me, right now, there's a gray area when it comes to retention. RSA 4168 talks about municipal records and sets the default for retention of municipal records at forever. So the question becomes whether or not a body worn camera recording is in fact a municipal record. There's a municipal records board that would have to designate a body worn camera as a municipal record or not. They haven't done so at this point. So unlike most of the statutes, the default for maintaining municipal records is you maintain them forever. There's exceptions in RSA 33(1)(a)(3) that allows you to destroy records sooner than forever. So for example, canceled checks you can get rid of 6 years after, bless you, after they've been used by the municipality. RSA 105(d)(2) does things a little differently because it says the body worn camera has to be destroyed within a certain time frame. There is an exception to that though. If it's used in civil or criminal litigation, it says it must be maintained for a minimum of 3 years, but there's no maximum retention, bless you again, within the statute. So because it's a minimum of 3 years and there's no maximum, again, if body worn cameras are in fact municipal records, which I think there's unfortunately a pretty good argument they are, they would have to then be maintained forever. That hopefully clarifies something.
And if I understand your testimony correctly, you're fine with the retention policy as stated in the bill?
Yes, absolutely.
Thank you.
Seeing no other questions, thank you very much. Anyone else wish to speak on 289? Seeing none, we'll adjourn the hearing.
Yeah.
Yeah.